So for this video, I will be talking about the case of Lucasfilm versus High Frontier. And this case was just really silly to me. Basically, complaints were filed alleging trademark infringement and related business torts. Sorry, but this case was held in the United States District Court in the District of Columbia. So the district court held that the public's interest groups used the phrase Star Wars to persuade the public of their respective viewpoints of Reagan administration's, Reagan administration's strategic defense initiative through television messages was not infringing use of the filmmaker's Star Wars trademark. What in the world does Star Wars have to do with any type of administration of any business? Like, I don't like the fact that they're trying to connect something that's, somewhat fictional to, business, because why argue about something in a sense that I feel like the judge may not even care about? So you're arguing your point that there was a trademark on the word Star Wars when there's technically not, because if that's the case, I wouldn't be able to use the word. Like, I wouldn't be able to use the word in any tense. Like, I wouldn't be able to just, put that on Twitter or anything like that. So from this case, the rules that I got were the trademark owner had no property rights in the use of the words commonly found in English language, which is true. Like, he had no trademark on not using the phrase Star Wars, which in a sense you can't really use that as a phrase because that is the title of a movie series and everybody knows that. So how would you then try to trademark that phrase? That would then become an issue with the company of Star Wars. He would then create another issue for himself. Trademarks composed of such words protects the owner only against those who seek to attach the word to products or services that compete within the marketplace. Reagan administration does not compete within the marketplace. They are over some type of business and they make sure that the business runs smoothly. So therefore, this administration does not, offer products or services that compete within the marketplace. They are just making sure that their business runs smoothly. They're more like, the top dogs in the case. I also seen that trademark laws reach only activities in which a trademark is used in connection with or selling to establish infringement that the defendant provides a service and uses a trademark. So basically, he would have to, Reagan administration would have to show that Lucasfilm was trying to provide a service or use this as a trademark to then produce infringement from this case. There was also another rule that I seen: unfair competition and related business torts do not reach the realm of public discourse to regulate the use of terms outside the context of trade. So in a sense, that really means that this rule can't be in play because there's nothing here that's being traded. They're not trading the Star Wars slogan to get any money. There's no switch off. There's no return. So the public interest groups use the phrase Star Wars to persuade the public of their respective viewpoints of the Reagan administration. And basically, through television messages, this was not an infringing use of the filmmaker's Star Wars trademark, even though using children in their messages, where the public interest groups use Star Wars in the body of the messages in a descriptive manner. So basically, to communicate ideas rather than to communicate confusion to sponsorship. So they weren't trying to use it to create anything negative, is basically what I understood from that. And after the fact, my analysis was there were two complaints alleging infringement of the plaintiff's Star Wars trademark involving the same questions of law and substantially similar facts, and that is Reagan's administration. The suits were consolidated in the plaintiff's motion for preliminary injunction in each case will be treated as submitting the issues for final resolution on the merits pursuant to another case. So basically, this case had so many, I guess, issues, or they had so many questions to address in this case, that they tried to consolidate it into one, but they were then really back broken up, in each case, got submitted for final resolution. And that in itself, you already created more issues, or really more things to spend money on for yourself. So in conclusion, the plaintiff seeks to enjoin defendant's use of the phrase Star Wars, alleging trademark infringement, unfair competition, misappropriation, disparagement, and a number of other similar business torts. The proof is presented at this stage, and leaves no doubt that Star Wars is still a strong trademark, and the defendant's television messages injure the value of the mark in some minds. Nonetheless, while the plaintiff admittedly faces an unfortunate series of circumstances, the court has no authority to provide the plaintiff with relief. So basically, in a sense, the plaintiff lost. And so Lucasfilm, and Higher Frontier weren't able to figure out who really, was in the wrong. So the defendant in this case was able to win.